You are sitting on a pending provisional application that is rapidly approaching its 12-month deadline. Facing a decision you probably didn't know you had to make, file a brand new non-provisional application or petition for formal conversion under 37 CFR 1.53C3. This explainer covers exactly which path to take and why most inventors choose the wrong one without realizing it. The stakes for this procedural choice are straightforward but incredibly high. Make the wrong move right now, and you automatically strip away one entire year of enforceable protection from your patent's lifespan. It's a quiet mistake that ends up costing inventors dearly. So, your provisional's 12-month deadline is coming up. What do you actually need to do right now? You have to make an immediate, binding decision on exactly how to move your invention forward into full examination at the USPTO. And that naturally leads to our next question. What's the difference between filing a new non-provisional and quote-unquote converting your provisional? And more importantly, which one are you supposed to do? You're basically standing at a procedural fork in the road with two very distinct technical options. On one side, we have the standard approach. This means filing a complete, brand new, non-provisional application that explicitly claims priority back to your provisional. On the other side is the alternative, filing a petition for formal conversion under 37 CFR 1.53C3 to essentially reclassify your pending provisional into a non-provisional. Since we've already established the stakes are high, you're likely asking, will I lose patent term if I pick the wrong option? The short answer is yes. The exact path you choose strictly dictates the start date of your 20-year protection clock. Here is how that math actually works. If you file a new non-provisional, you preserve a full 20-year patent term measured from your new non-provisional filing date. But if you choose formal conversion under 37 CFR 1.53C3, your 20-year term is measured all the way back from the original provisional filing date. You instantly and permanently lose up to a year of enforceable patent term. Having reviewed priority claims from inside the USPTO, we know there was really only one narrow situation where formal conversion actually makes sense. That's when a public disclosure happened before the provisional was filed and the one-year statutory bar under 35 U.S.C. 102b1 is closing in. In that highly specific scenario, formal conversion retroactively applies the provisional's earlier date to preserve patentability. Otherwise, it's just the wrong choice. Let's tackle another very common technical issue. Can you add new information or improvements to your invention when you file the non-provisional? This shifts our focus directly to the examiner-level problem of introducing new details. Under 35 U.S.C. 112, your original provisional must provide complete written description and enablement support for every single element in your later claims. From an examiner's perspective, your claims only get that highly coveted earlier priority date if every technical detail was fully described and enabled in your original filing. So here's the crucial point. Adding new matter actually splits your priority dates. Claims supported by the original filing get to keep the earlier date. But any new claims relying on the new matter are stuck with the later, non-provisional filing date. If your invention has evolved significantly over the last year, filing a continuation in part, or CIP application, is the proper strategic vehicle to handle that split. Now, let's look at the logistical realities of USPTO examination with a very practical question. How much is this going to cost, and how long will it take? The USPTO relies on a tiered electronic fee structure that combines your filing, search, and examination costs. Currently, it runs $2,000 for large entities, $800 for small entities, and $400 for micro entities. Be warned, though, paper filings or submitting a specification in a non-DOCX format will trigger additional, completely avoidable surcharges. If you want the full fee breakdown by entity size or the exact process for restoring a late priority claim under 37 CFR 1.78b, the article covers both and it's linked in the first comment below. As for the timeline, you will definitely need some patience. Once your non-provisional is filed, the typical wait to receive a first office action from an examiner is anywhere from 16 to 24 months. That long timeline makes the 12-month window even more critical, which brings up our final viewer question. What happens if you miss the deadline completely? Missing the strict 12-month window governed by 37 CFR 1.78 has severe consequences. There is absolutely no standard extension. Your provisional application expires automatically by operation of law, and your priority date is permanently lost. Furthermore, any public disclosures, sales, or publications made during that provisional period instantly become prior art. That can completely destroy your patentability. There is one narrow exception under 37 CFR 1.78b, which allows a petition to restore a late priority claim within 14 months. However, this is strictly a procedural remedy for genuine, unintentional administrative failures. It is never, under any circumstances, to be used as a strategic planning tool. We also have to warn you that this identical 12-month clock applies to international protection. Your provisional filing date triggers the Paris Convention deadline for PCT applications, which eventually have a 30-month national phase entry deadline downstream. Many inventors make the mistake of waiting until month 11 to begin drafting. This is a deeply flawed approach. Rushing at the deadline almost always produces narrow, underprotected patents. We strongly recommend beginning your audit and drafting process around month 6 to allow the essential time needed to thoroughly analyze your written description. Here is the exact systematic process to prepare and file. Step 1. Audit the provisional. Step 2. Prepare the DOCX specification. Step 3. Prepare formal drawings. Step 4. Prepare the application datasheet, or ADS, and the inventor's oath. The ADS is incredibly critical because it formally establishes your priority claim. Finally, Step 5. File electronically via Patent Center. Think of the examination queue very simply. The application that arrives in the queue first gets reviewed first. Filing earlier than 12 months physically moves your application into the queue faster. Your original provisional priority date does not give you a VIP pass to skip the examiner's line. So let's step back and look at the core takeaway. For nearly every inventor, filing a new non-provisional application that claims priority to the provisional is the right move. Formal conversion under 37 CFR 1.53C3 is almost always the wrong choice. If you want the full step-by-step filing process and the written description audit checklist to determine which of your claims actually keep the earlier priority date, the full article is linked in the first comment. As you prepare your filing, you have to ask yourself, is your provisional actually strong enough to survive an examiner's scrutiny and support your final claims? Subscribe if you want more patent and USPTO guidance without having to search for it every time.